welcome to all of you to this webinar on litigation to the Court of Justice of the EU in the field of immigration detention and alternatives to detention for migrant children. I'm Karolina Babicka, Senior Legal Advisor at the International Commission of Jurists, and I will moderate this event. We are very pleased to see so many of you here and still more joining. So let me start with a brief introduction of the International Commission of Jurists. We are a global human rights organization working towards the progressive implementation of international human rights law into national legislation and practice, with the goal to ensure access to justice for the most marginalized in the society. We have been working in the field of rights of migrants for many years now, and the rights of migrant children in particular. And with our work, we aim at minimizing or rather eliminating immigration detention of children, which is unfortunately still widespread and overused. It is in breach of international human rights standards, such as the UN Convention on the Rights of the Child in light of its general comments, as the impact of detention on children is clearly severe and long-lasting, as the UN Global Study on Children Deprived of Liberty stated, by deprivation of liberty, we are depriving children of their childhood and of their future. We organized this event as part of an EU-funded project, Release, which is a collaborative project with our national partners in 6 EU member states. And we will be looking today at litigation in the field of immigration detention of children to the Court of Justice of the EU. The Court of Justice of the EU is an important litigation venue in the European Union, and it's also very specific, as it cannot be accessed directly with individual cases like other international courts or bodies, but mainly through preliminary references asked by national judges of EU member states during proceedings at national level when applying EU law, or through infringement proceedings, when mostly the European Commission launches proceedings to the court for a member state's non-compliance with EU law. And we have some very knowledgeable speakers here with us today who will shed light on these proceedings during the webinar. Let me just say that after each speaker, we should have about 15 minutes for discussions. So please share your questions in the chat, and you should have the opportunity to come in and ask them after each speaker. And so our first speaker is Igor Taccani, who works as a lawyer at the Court of Justice of the EU. And he will speak about the preliminary rulings procedure. He will share some case law examples and focus practically on how to formulate effective preliminary questions. So thank you so much, Igor, for joining us today, and the floor is yours.
Good morning. Hello, everybody. It's a great pleasure to be here. So today my presentation will focus mainly on the preliminary ruling procedure, which is this procedural tool that national judges have to put questions before the Court of Justice, and it's as we will see, a cooperation between national judges and the Court of Justice, which plays a very, very important role on also in immigration law, and there are several cases also concerning detention of migrants. My presentation builds on another seminar that the International Commission of Jurists organized here in Luxembourg a few weeks ago. I have a limited time, so I will go through the presentation relatively quickly, but I will be happy to give the presentation to put it at your disposal. And so if you have then any question, we will have the 15 minutes at the end of the presentation to go deeper on certain issues. So the presentation is subdivided into four parts. We will go very fast on the first one, the introduction to the structure and jurisdiction of the court. Then we will concentrate on the preliminary ruling procedure. Then we will see also how to formulate effective preliminary question before the Court of Justice. And then we'll speak about the procedure. And if we have a little bit of time, also what happens after the Court of Justice has given its ruling. Before we start, I would like to bring you, by the way, I'm in Luxembourg at the court in this moment, so greetings from Luxembourg, but this is the heart of the Court of Justice. It's la grande salle d'audience, where all the most important hearings take place, namely the one of the Grand Chamber of the court. So the first part, overview of the institution. So the Court of Justice of the European Union is the court of the European Union. And the highest body, if you want, concerning EU law. It has two judicial bodies, the Court of Justice itself and the General Court. The Court of Justice is composed by 27 judges and 11 advocate generals. So here you have the current composition of the court. Of course, one judge per member state. So 27 member states, 27 judges. The court sits in chambers. So you will never see a judgment of one judge. The standard composition is the 5 judges chamber, and this is also a practical advice. If you see a judgment of the court, go and in your work, go and check the chamber, the composition of the chamber, because this will tell you the importance of the case. Of course, if the case has been decided in Grand Chamber, it's an important case. If it's decided in a chamber of 3 judges, it means that it's a less important case, which is based on existing case law. I'm working with an advocate general. Very few words about the role of the advocate general, who is an advisor of the court, which in the most important cases and the cases that raise new question of law, issue an opinion on his name, and it's a necessary procedure, a step in most of the cases. But of course, the court is not bound by the opinion of the advocate general. Then few words on other services, and the most important thing is here is that the Court of Justice is a multilinguistic institution. So we work in French, so everything is translated in French. Of course, any judge or any legal or natural person that want to come in front of the judge can choose any language of the language of the member states or any language of the European Union, but everything will be translated into French. So it's very important to keep this in mind, so clearness and clarity and the shortness, brevity are very, very important concepts. We'll come back on this after. So we will speak about the reference for a preliminary ruling, but of course the court has other jurisdiction in other type of actions. In particular, we will be speaking after on infringement proceedings, but also action for annulment and other types of actions for non-contractual liability. But these are all, apart from the infringement proceedings, they are all less relevant in the sector that we are discussing about, so in immigration law. Few data on the case numbers, but just to show that the preliminary ruling procedure for the Court of Justice, at least as the judicial body, plays a major role, because around 62% of the cases concern references for a preliminary ruling. And in the area of freedom, security, and justice, this is the area in which there are more reference for preliminary ruling than any other sector of EU law. So that's a very important number. So that was the presentation of the institution. Let's go and have a look at the preliminary ruling procedure itself. So what is the preliminary ruling procedure? So it's a fundamental mechanism of EU law, which, as I was mentioning earlier, it's basically finalized to ensure the uniform interpretation of EU law within the European Union. So EU law applies, of course, in all member states in different forms. And so this is an instrument which allows national judges to go to the court and ask for interpretation of validity of the of EU law, and it ensures that EU law is applied everywhere in the same way. And it's an instrument of cooperation. But watch out, a cooperation between the Court of Justice on the one hand and the national courts. And here already we will come back to that, but the parties play a limited role in the preliminary ruling procedure. So not completely zero, let's say, but it's a cooperation between national judge and the Court of Justice. So once the order or the decision for the preliminary ruling is sent by the national judge, the court will base itself on this decision. The party will then intervene in the hearing. If there is any hearing, they will provide their observation, the written observations, but it's very, very important what the national judge gives to the court, the information that the national judge gives to the court. And this is very important to keep in mind. So it's a peculiar and exclusive competence of the Court of Justice, but there's been a reform in 2024 that allows also now the General Court, which is the lower court, to have some competence, but not in immigration law. So it's a non-adversarial procedure, because the real litigation is in front of the national judge, and it's a dialogue between the national referring court and the Court of Justice. Very important, the Court of Justice is not competent to decide on the case in the main proceeding. The Court of Justice will interpret EU law or declare the validity or invalidity of EU law always, and not on national law. So what are the relevant texts here? So the most important one is Article 267 of the Treaty on the Functioning of the European Union, which is primary law and gives, we will see it right now. Very important also the rules of procedure and the recommendation to the national courts and tribunals. So this is a form of soft law, but which is very, very important. All these texts are available on the web page of the Court of Justice, so you can go and find them and read them in case you have to work on a preliminary ruling procedure. Or what is the role of the lawyers here? Most importantly, the role of the lawyers is to advise, if you want, the national judge, suggest to the national judge to make a preliminary ruling in certain situations. So we will maybe discuss about this in the questions, but it depends really on the relationship that varies between member states to member states, between the judges and the lawyers. But it is thinkable, and in certain jurisdictions it's definitely possible that the party invites the court to, so the lawyer basically invites the court to submit a preliminary ruling procedure. Many times it's the preliminary ruling procedures are somehow initiated by the party that convince the judges and national judge, because it's always the national judge that will send the request for preliminary ruling. So Article 267 of the TFU, here we have everything, basically the object of the preliminary ruling proceeding, so the interpretation of EU law or the validity of secondary law and then also the distinction between obligation to have a preliminary ruling or the possibility. We will see it right now. So we'll see first who, what, when, and how. So who can refer? Well, we said that a court or a tribunal of a member state. So what is a court or a tribunal? What is a court under Article 267? Well, this is a notion of EU law. So regardless of the definition of court under the national law, and there are some criteria that have been developed by a court to establish whether a body is a court or not. And you see them listed here, but basically independency and the reference to the law and the application of the rule of law. So then we said that there is a court which is not a court of last instance, may refer a question to the Court of Justice when it considers that it is necessary to enable it to give a judgment. So basically, there is no obligation by a national court in principle to make a preliminary reference to the court. But if we are talking about judges of courts that are not courts of last instance, there is only an exception. There is an obligation to refer to the court a question of a preliminary ruling question if the court, national court, doubts about the validity of EU law. On the contrary, there is an obligation to refer if the court is a court of last instance, and so there is no judicial remedy under national law. So in this case, the judge is required to bring a request for a preliminary ruling if, of course, the preliminary ruling is necessary, if the matter, the question of interpretation of EU law or validity of EU law is necessary to decide the case which is pending before it. What happens if the national court, which has an obligation to refer, does not refer? There is just a possibility to make an action for damages against the state. So I was already explaining that the parties play a minor role here, so an important role in practice, maybe because they can convince the judge, but they cannot bring and not even bring directly, let's say, a preliminary ruling request to the court. So this was who can refer, so national courts. What can be referred, and here we already anticipated, a request for preliminary ruling must concern the interpretation or the validity of EU law, interpretation of any act of EU law, so typically a directive. So, for instance, there is an issue concerning application on national refugee law, which comes straight away from a directive, and there is a doubt on the interpretation of the EU directive. So this is a typical case of request for interpretation of EU law, or the validity, if there is validity, but only of secondary legislation, secondary law. So not, of course, of the treaties. So what does the preliminary ruling procedure not concern? It does not concern the interpretation of the validity of rules of national law, issues of fact raised in the main proceedings, opinions on general issues not related to the case, and also purely internal national issues. So it's very important that the referring court sets out all the relevant matters of facts and of law, and I was telling it earlier on, in order that the Court of Justice can decide on the case. Then let's have a look also on the interpretation of the Charter of the Fundamental Rights of the European Union. And here it's very important that if there is a request for a preliminary ruling concerning interpretation of the Charter, then it's absolutely necessary that another provision of EU law applies to the case. So when can a reference be lodged? But any time during the proceedings, it's up to the national court to decide it. But of course, I mean, there needs to be a certain the level of advancement of the case in order to have all the elements that can provide the Court of Justice with all the information necessary to judge, basically. So let's go to the third part. So formulating effective preliminary questions. Here there are some examples of preliminary questions sent by courts. So here, of course, this is extremely long, ununderstandable, and you have also to think that it will be translated into French. So this is a bad practice. And this also is a very bad practice, but this was sent a few years ago. Of course, just this is the preliminary ruling request. The request for preliminary ruling, just one page, handwritten. It's not a good example. But here there are Article 94 of the Rule of Procedure explains clearly the contents that of the request for a preliminary ruling, and so I would advise really to read it and to hand a copy to the national judge before the national judge starts drafting the request for preliminary ruling. And here you have basically a summary of the subject matter of the dispute. Of course, the court needs to understand what is the dispute pending before the national judge, the tenor and national provisions, and the relevant national case law, and a statement of the reason why the referring judge wants to have basically this interpretation or has some doubts on the validity of EU law. And here, the most important sources that I was mentioning earlier on is the rules of procedure and this document on the for the national judge, the guidelines for the national judge. There, everything is written in a very clear way. So here we can maybe go faster, but you can see that. Basically, the forms, so the request should therefore be drafted simply, clearly, and precisely. It will be translated. So this is also very important. It should be also relatively short. So suggested length 10 pages. If it's longer than 10 pages, then there is a risk that it will be summarized. Of course, these are, again, guidelines for the national judge. So it's up to the national judge to make the request. But as a private lawyer, you can definitely try to put in evidence to the judge all these requirements. So here you see some suggestion to the referring judge need to take into account different legal cultures. For instance, I am Italian and I will never work on a case which is coming straight to Italy. So because that's the way it works here. So you have to think that if you're coming, for instance, from Hungary and the Hungarian judge and a national judge will make a reference, so most likely the persons who will work on the case will not speak Hungarian, will not have the possibility to get into the files of the case. So everything will be translated. So the questions themselves referred for a preliminary ruling must appear in a separate and clearly identified section, and they should be self-explanatory. Okay, let's see then in the last 5 minutes, let's have a discussion about the procedure, so how it works, how is a case treated in front of the Court of Justice. So there are two phases, so written procedure and a possible oral procedure. So first of all, the request that will be sent by the national judge will arrive to the registry of the court, and it will the case will receive a number. So C with a register number and the year. then the registry will send the request to the translation service, first of all, and to this research and documents department, which will make a preliminary analysis and will try to sort the manifestly inadmissible cases from the other cases. Then the case will be handed to the president of the court, which will appoint a judge rapporteur and a first advocate general, which will appoint an advocate general. So basically, when the translations are ready, then the registry will send the request to the participant in the preliminary rulings. And here, generally, before the court in preliminary rulings procedure, you have always the European Commission, which intervenes and will play a kind of amicus curiae role, so as advisor, if you want, without any specific interest in the case. Then generally the member state, the government of the member state from which the case originates, which will also participate. And then, of course, the parties, the parties will have a right, the parties of the case pending before the national judge will have a right to participate. And they may lodge written observation. And here too, there are practice directions to the parties. I mentioned them at the beginning, and I advise to read this document should you participate in a preliminary ruling procedure. Yeah, so I said who the parties are. Who is participating. Once the preliminary once the written procedure is closed, then the judge rapporteur will write a preliminary report that will be circulated inside the court, and it will be decided how the case is going to be treated procedurally. So whether the formation will be 3, 5 judge or grand chamber, if there's going to be an opinion, yes, of the advocate general, yes or no, or whether there's going to be an oral hearing. And then if there is a oral hearing, there will be this oral hearing. And here also the advice is to be short, and then a possible opinion of the advocate general, and then deliberation, and then basically the delivery of the judgment, drafting of the judgment, and then which will be translated and then delivered. An important, and then we have 1.5 minutes. It's very important to mention that in the sector of immigration, there is the possibility to have this urgent preliminary ruling procedure, so-called PPU, which is and it's rather this one, which is foreseen, provided by Article 107 of the Rules of Procedure, which applies in case of urgency. And this is the case in which there is, the two main cases in which the court grants this kind of super fast procedure is if a person is in detention, so our case, and also if there is an irreparable risk of compromising the relation between parent and child. So let's say the situation of children is really one of the most important elements that are taken into consideration to give this preliminary ruling procedure. And in this case, you have to think that the preliminary ruling procedure is an incident within the case pending before the national judge. And so it lasts around 15 months. You've seen it's quite a complex procedure. But if the PPU applies, then the duration of the case will be reduced to the minimum possible, which is between 2 and 3 months. Okay, so I would say we can stop here perfectly at 12 o'clock. And I'm up for the discussion. I mean, I ran a little bit through the presentation. It will be my pleasure to share it. We already said it. So, and do not hesitate also to contact me if you have a question also after that. And so I give the word to Carolina, I think. Yeah. And if there is any question, I'm happy to discuss about that.
Thank you. Thanks a lot, Igor, for sticking to the time limit, very tight exercise, and also for presenting very well the framework of the CJEU and the preliminary reference procedure. I think we have, to a large extent, national EU lawyers here with us today, and so I can imagine it's inspirational for them also on when and how to request the preliminary question to the court in national proceedings. So if you would have any questions or comments, please either write in the chat or raise your hand, and then you can present yourself and make your comment or ask your question. So feel free to come in. We'll have about 10-15 minutes for discussion.
I hope everything was clear, because yeah, I ran through the presentation a little bit. If there is any, okay, I see a raising.
Yes, Jessica, please go ahead.
Hi, Igor. Hi, Carolina. Thank you so much for that presentation, Igor. My name's Jessica Hazelwood. I'm from Save the Children. No surprise where my question's going to be directed to. Could you talk a little bit more on any sort of, you said there was an accelerated process when it concerns children. Has that been expanded in the jurisprudence at all, or is it quite rigid? That's my first question. My second question was, you gave us some examples of not ideally written preliminary ruling applications. Can you give us an example of one that would be good? I know you gave us the criteria, but have you got one that you could share with us that would be helpful for us moving forward? Thank you.
Yeah, with great pleasure. Thanks for the questions. So as concerned the first question, which concerned urgent preliminary procedure. So if you read the slides, you will see that there are actually two forms of expedited procedure. But the one which is interesting in this forum is really the PPU, which is the fastest one, and which has a limited scope of application, and exactly it applies to the area of freedom of security and justice. So it's really the procedure that you should be using in case of detention of children. So absolutely, and I think that in case of detention of children, there would be no doubt that the court would allow it. Although the court is very strict in granting this type of procedure, because it somehow disrupts the working of the court, because you have to stop all the other cases and work on the one which is super urgent. But still the case of detention in general of a person, which is even provided by the Article 267 paragraph 4. We didn't read it, but if you see in the slides, you will see that it's exactly the case of detention. And the case of actually in the case law, it has more, because I mean there is no really distinction between detention of children of detention of adults. So if there is detention, there is urgency. So that's the case law. On the contrary, as regards children, the case law regards rather situation of relation between parents and children. So typically a matter of competence if one of the parents has escaped from a member state to another one with the children and the other. So that's the case law that has developed concerning children. But otherwise, the issue is detention. If you can prove detention, that's enough to trigger. Well, and of course you have to show that the matter which is the object of the request, of the preliminary request, is decisive to avoid detention. So in the sense that if the court interprets in a certain way, then the person will be freed. And it's very important, I stress it, but that it's actually the national judge, so the one who makes the request, that needs to provide the elements to the court. So not let's say the party, not the lawyer. No. So of course, if you want, in a indirect way, no, through the national judge, you have provide. Then, as concerned the second question, of course, I showed mainly what we call not the court, but let's say here, I mean the pathological cases, no, the cases which are negative. But you can there are plenty. So since the last 5 years, 3, 4, or 5 years, the court is publishing the request. Then on the webpage, so you can find many cases that I mean the cases that have been considered admissible, so are in principle good example. But I would really refer to this document, so the guidelines for the national court, and there you really see what the court wants somehow. No, so. Stick to the 10 pages, be clear. Well, I'm speaking to the judges in reality. So again, but there are cases where there is there are all the elements that are indicated in Article 94 of the proceedings. So the court gives all, but not unnecessary elements. Okay. The questions are formulated and self-standing. So you read the question and so these are, if you want, general formal elements, and then of course there is then the more substantive aspects of the questions, in the sense that you have to ask for interpretation of EU law. Or validity, no, but less likely. So, and when there is a mixture between national law, because there is transposition in let's say in the member states, on the law of member states, and the EU law, then it becomes more tricky. No, if you want but if you want, I can make a little research and give you a couple of cases that are and mention them to Carolina, and maybe she can send you. But yeah. So if you go on the webpage, you find lots of so they may be published. No? So now all of them. So
thank you. Okay. Thanks so much, Igor. Yeah, I think this was really, really good. I see also there's a question from Tomasz in the chat, and please come in and ask it.
Okay, thank you very much. Thank you for the presentation. I wonder, because procedurally the decisions on extension of detention are issued every 3 months. So if the judge that is given 1 week notice before the end of detention, or when he's got 24 hours to decide about the detention of children or families or anybody, is to suspend the procedure and refer the question to the European Court for Justice, the European Court of Justice, then I believe that when the decision is issued by the preliminary ruling is issued by the Court of Justice, that the whole aspect of detention is already the historical issue, I would say. I know that we represented children that were detained for 1 year, let's say, together with families. So maybe in some cases it is possible that the preliminary ruling will be given, within 4 months, and the persons are still in detention. But generally, I think it plays role for compensation for arbitrary detention, but it has unlikely effect of shortening detention of children, because I believe it's hard to imagine that the detention will be lasting so long to wait for the judgment.
Yeah. Well, the point is now the PPU is really the minimum time possible to reach to a decision. You have also to think that, and if there is no detention anymore, then there is actually no reason anymore for PPU, actually. So, well, once it has been granted, usually, I mean, the machine is in movement, so it's not that then after it becomes, I mean, it's withdrawn, let's say. But of course, you have also to think that the questions that are raised to the court relates to the interpretation of EU law, and the judgment has an effect which is binding and interpreting it, if you want, forever, unless on that. So, I mean. it's a complex procedure, so there is no way that it can be shortened more. So already it's a maximum level of urgency, and also there are some rights of the parties also that needs to be granted, that needs to be translated, and there is also a need to for the court so the member states will need to prepare their observations. No, the parties will need to prepare observation. The document needs to be translated. There needs to be a hearing if there is. No, so if you see that in the reality, 2 to 3 months, it's a short time. It's impossible to go shorter than this. And then again, if the person is still in detention, then the ball goes back to the national judge. It's up to him to free the person. If the person has already been freed, then the reason for the urgency is not there anymore. I don't know if I answered to the question, but
yes, I think it's super fast. 3 months, for the preliminary ruling, it's a super fast procedure. But I wonder if I was a national judge and I had to decide about the 3 months extension of detention, and I would know that after I make a hard work of submitting preliminary reference to CJEU, I will have to wait 3, 4, 5 months for the answer. And I know that I'm deciding about the 3 months extension. I don't think it's practically to be used by the judge when if there are doubts about let's say the possibility of legal detention of families. I think the normal decision would be not to grant the detention order, not to issue detention, not to extend detention.
If you want, this would be a good result, even no. I mean, as a lawyer, you could somehow propose. No, well, in the sense, it's on the if you want, it's on the discretion of the unless it's a judge of last instance, no. It's on the discretion of the national judge. If the judge thinks that it's necessary to have this answer, then he will submit it. Of course, then it depends on the sensitivity of the national judge. That's definitely. If he thinks that it's not necessary because in any case it's going to be freeing the person, then he will not do that. But if it's a case, if it's a judge of last instance, then there is an obligation. But okay, in this case maybe it's a little bit less common. Okay, I hope I answered, because I see there are other.
Thank you. Yes, we can go next to Claudia Preto.
Thanks. Thank you very much, Igor, for your presentation. I was just thinking about the protection of minors. I have the opportunity in the past to work as a researcher in the Darboe Camara case in front of the European Court of Human Rights. In that case, minors were not exactly in detention, and we were lucky on this, but they were in deprivation of reception rights and at risk of inhuman treatment. So from the side of the lawyer and the guardian, we decided to go through the European Court of Human Rights through the Rule 39. And immediately the order to the state arrived to put in protection in another reception center the minors. So from the perspective of the protection of minors, effective protection of minors, from the perspective of the lawyer or the guardian that are obliged to protect, of course, as soon as possible, in the best way, the best interest of the child. My question, open question, and I really would like to know your opinion. We are lucky because we have the PPU, but in a situation of risk and need of effective protection, maybe a Rule 39 to the European Court of Human Rights could be more strategic to protect the best interest of the child. This is an open question, of course. I have no answer. I'm questioning also from the perspective of effective protection of the minor. Many thanks.
It's a very, very interesting question from let's say, very also interesting perspective. I mean, here again, it really depends on the. So there, I don't see why you shouldn't. Maybe if you want, proceed with both ways. The preliminary ruling procedure presupposes the existence of a case before the national judge. And an issue of EU law, which is decisive for the solution of the case. No, of course, then it depends on a case-by-case basis, and I also connect to the questions before, no, and of course there are like many possible situations, no, and also they depend. We were discussing also in the other seminar, no, on the different national member states, on the judge that you are in front of, if it's a good judge or bad judge. Of course, if the point is there is like a perspective of long detention, no longer than 6 months, or at least 6 months long, so that indeed the judgment of the court can have an impact on the case. And the judge, national judge, is open to make the question. The question is decisive. I think it's a good idea to push to have a preliminary ruling procedure, but if it's an obstacle to the liberation, then better not to proceed. And in any case, I don't see. I'm not an expert now in the European Court of Human Rights, but I don't see why one couldn't proceed with both ways. But maybe Gruša has also very direct experience in this and can also provide some. Because I remember that we had a kind of some similar discussion here in Luxembourg.
Thanks a lot, Igor. And yeah, perhaps Gruša, if you want to come in now or after your presentation.
Yes, sure. Thank you. Exactly. These two procedures can be run together. So, for example, if you are aware of our FMS case, so the transit zone detention case, which was the preliminary reference case, well, part of the case, so the S part of the case, the father and his son, we also brought to Strasbourg. We also requested Rule 39 there, and at the end, we got also a positive judgment, even for Strasbourg. They were detained. Of course, this judgment came after FMS case, but what brought it's the compensation, right? Additionally to the FMS. I think why preliminary reference procedure is so crucial, what Igor mentioned several times, is because it interprets the EU law that will be then applied in all similar cases. So you don't have Strasbourg judgment, of course, also, should have this general application, but when it comes to the CJEU judgment, this is much clearer. I mean, because it's the same legal provision interpreted in this domestic setup. So whenever Hungary or any other country will have a similar case, they will have to apply the EU law as interpreted by the CJEU. So maybe it will not directly help the current clients, right, that are there, that you are having the case referred to CJEU, but all other cases will benefit from that case. So I think it's important to try to do both. But of course, for each and every case, you should develop your own strategy. You know what's best, both in the national context.
Exactly. I would like to connect to this also in connection to the case before, to the question before. They are related, the two questions. The effect of the judgment of the Court of Justice goes beyond the single case. So there may be an interest which goes beyond the case to get rid, for instance, of a national provision of an interpretation of national law by national judges that is manifestly opposite to EU law, for instance. No, so in which case there is an interest to ask for preliminary reference that goes beyond the single case, which is triggering, if you want, the preliminary reference.
Thank you. Thanks a lot.
I see there are some questions in.
yeah, we just have to finish and go to the next part. So we have two last questions, I think, here from Ricardo and Suzanne, if you want to come in and ask your questions. Or, yeah, Igor, if you're reading them.
An example where lawyers have played a significant role in collaborating with national judge to initiate preliminary. Also, this, I mean, from our perspective, it's a bit difficult to see that because we communicate, if you want, with the judge. There are, I mean, sometimes you understand it from the request for a preliminary ruling. Although I must say one thing that so you understand that the judge basically took the arguments of the party, and which is probably, you know, the in abstract. Then again, it depends on the concrete legal system, on the relationship between the lawyers and judge within that legal system, on the judge that you have in front of you. No, we're saying about good judges, bad judges, good, no. But basically, the best way that you can, in practice, act, if you want, is to try to really make the job for the judge and draft somehow as much as possible a request for preliminary ruling. But it's very important that the court does not just say, okay, the lawyer, no, in the document that will come to the court, does not just say the party said that, the part. So the judge needs to make, the national judge needs to make these arguments and these its own arguments. Okay, because there are cases indeed where, you know, there are even from highest courts where there is basically copy and paste of the observations of the party of the from in front of the national judge, and the national judge does not make it. It's not its own reasoning, if you want, and this becomes problematic. So I don't know if I explained.
Yeah, and just to maybe add that also the case that Gruša just mentioned, the transit zones against Hungary, there has been actually good cooperation between Hungarian Helsinki Committee and the judge, but she'll probably talk about it also in her presentation. Yeah, and then there is a last question, Igor, related to human trafficking.
I'm not aware about any case pending at the moment. This does not mean that there might not be, because I mean, I don't have complete knowledge of the whole case law and all the pending cases. It's relatively easy to make a research if you want. You can go again. I refer to the webpage of the court, which is well made. I mean, I leave it to the practitioner outside to give judgment on the quality, but I think it's full of resources. So there is a good research form there, search form, and you can easily see. And there are pending cases and of course past cases. So if you go on this form and you like put make a research, you can easily find if there is anything pending, which is of your interest or not.
Yeah, thank you so much, Igor, for the presentation and for also engaging in the discussion. We have to move on, but perhaps there will be more discussion after.
So bye-bye and
yeah,
have a good day.
No,
bye,
thank you.
Bye.
And we're moving ahead with the second part of the webinar, which is on going to focus on the infringement proceedings. And our second speaker is Gruša Matevžič, who is a senior legal officer at the Hungarian Helsinki Committee within the refugee program, also coordinating the work of the strategic litigation team in Hungarian Helsinki Committee. And she will speak mainly about the other channel to reach the CJEU, the infringement proceedings, and how these can support strategic litigation with some concrete examples of previous successful cases. So Gruša, you can share.
Yes, thank you. I will try to share. Oops. Wait, let me see. Do you see?
We see the presentation with the small bar on the side.
And now?
Yes. now it's perfect.
Okay, thank you. So since I have the floor, I will first answer to one of the questions written in the chat about the good practice, because then I will focus on the infringement procedure. Of course, this doesn't mean you can't ask about the preliminary reference experience at the end, but just to conclude with the first session. So the good practice that we have developed, and so far Hungarian Helsinki Committee had 14 cases with preliminary reference in the field of migration. So we kind of reached some kind of agreement with the judges that when they, in the appeal, we raised the issue that there should be a preliminary reference. And then if the judge seems to agree with that, we always add like one sentence that if the judge would agree to refer a preliminary reference, then we would request additional time to submit reasoning for preliminary reference. And that's when, I mean, of course, we explain in the appeal why we think preliminary reference is needed, but then when we get this additional time granted, then we actually draft the whole preliminary reference with questions, then, relevant legal provisions, national, European, and then the reasoning. So why is it in this context necessary to ask these questions that we specifically formed? And in many cases, it turned out that the judge really took our reasoning. Of course, they did express it's their own opinion as well. As Igor just mentioned, it's important not just say the applicant is saying, so that's what we are forwarding, but you could see that in the reasoning they used our arguments, and that's very important because you need to influence how the case will be going. And the first cases that we had, we didn't have experience, so we did not yet collaborate that much with national judges, and the preliminary reference asked at the initial first cases many years ago turned out not to be really useful for the whole system because they were not really formed in collaboration with the lawyers. So I think this is a good practice. But now the infringement procedures. So here, this is not, as this is not something that an NGO or lawyer is an official party in this procedure. So everything that could be done, it's done, around it, and it's done informally and not like as an official part of this procedure. So before I go into the concrete examples, I just want to repeat for some who might not be so familiar what the infringement procedure is. So it results from the Treaty on the European Union that the European Commission has a duty to monitor the member states' action in implementing EU law and to ensure that member states' legislation and practice complies with it. So infringement procedure is a procedure that is started by the European Commission. And it starts in a case where a member state breaches EU law. So this procedure is really discretionary. There is no rule that says the European Commission has to start infringement procedure. And from our own example, we see that, it's really at the end of the day, it's the will of the Commission, is their own decision, and it's quite also political in nature. I will give an example. But what the Commission is saying is that they usually start an infringement procedure where there is a persistent or systemic failure to implement EU law. Now, the political nature that I mentioned is that we initiated several complaints to the European Commission, and some of them, for example, regarding the temporary protection directive, the way it's implemented in Hungary, with several issues arising. I won't bother with that. We initiated the complaint already in 2022, but then supplemented it in 2023 and 2024 with issues that we believe are very problematic. Well, so far, no infringement procedure was started. The first answer that we received from the Commission was that right now they want to, when the whole temporary protection directive actually started to kick in, then they were saying we have to assess how all the member states are implementing. the directive, and then we will see whether we will start an infringement procedure against a certain member state. Well, that was several years ago, and since then we didn't even receive any answer anymore, and not even that they registered our latest supplement, which was in 2024, regarding the deprivation of accommodation for beneficiaries of temporary protection. So you see, this is really political. Like, the Commission obviously does not want to attack Hungary also on that level, but that doesn't mean, you know, we want to criticize Commission right now, because, as you know, unfortunately, Hungary is in non-compliance with the EU law on several segments, and then there has to be some kind of prioritization as well, and some are just so serious that Commission is probably prioritizing those. And then, how does this procedure actually look like? It starts with a letter of formal notice that is sent by the Commission to the member state. It follows by the reasoned opinion if the member state doesn't immediately, you know, comply, like adopt some measures that would seem that they comply with the EU law. If after reasoned opinion, member state still does not sufficiently comply with the EU law, then the Commission can refer a case to the CJEU. After that, there is a judgment, and if the CJEU finds that the member state is not complying with the EU legislation, member state should implement this judgment. If it does not, then the Commission can send another letter of formal notice saying that we think that you did not comply with the CJEU judgment. And then if still there is no compliance, then the Commission can refer for the second time to the CJEU the same issue, and there the Commission can request a financial sanctions. So I will show this how it worked in one of cases against Hungary, but you know, what I can share is from those cases that address Hungary and that we could somehow follow, but otherwise this whole procedure is confidential. So all you can know about it is what is published on the Commission website, and often the information is quite scarce, so you don't really even know what exactly is part of the infringement procedure, which parts of domestic law, and so on. So this is really a confidential procedure. Now, I will look into the second part of my presentation into three concrete, more case examples, but three main topics. One is the pushback case. The second will be the access to asylum, or the so-called embassy procedure case. And then the last three will be the cases which address the attacks on civil society. The pushback case. So I like to call it the pushback case because many confuse it with the transit zone detention case, but because it also covered that part. But for us, this is really a pushback case. I will explain why. So we have two judgments in this case. The infringement procedure initiated by the Commission started already in December 2015. But as you can see on the slide, that pushback legislation, so you know, in Hungary, whoever is found illegal on the territory should be removed to Serbia without any registration, without any possibility to apply for asylum, nothing. So this law actually entered into force only in 2016 for the 8 kilometers if you are found within 8 kilometers from the border, and then in 2017 if you are found on the whole territory. But the infringement procedure started, as you could see, already in December 15, but was covering different issues. It did cover transit zone detention, but not the pushback. So not to, you know, have the Commission again start from the beginning, they luckily, because the Helsinki Committee immediately raised the attention on these two on the new legislation regarding pushbacks. And again, what I'm telling is not that, you know, because Helsinki did this and that, we don't know, you know, why Commission reacted, but I'm just gonna say what we did, and we believe that maybe we did influence by our actions also the actions of the Commission. So we immediately published about it. We analyzed the new law, we showed the implications, we published. So the Commission actually extended the existing infringement procedure to the pushback as well. So it was covered. And then, because there was no compliance, they referred the case to CJEU in December 2018. And then there was a hearing, and through all this time we tried to assist the Commission informally. Of course, you are not officially part of the procedure, you are not told, help me, but we were trying to figure out what would be useful for the case. So we were publishing, for example, we had access to, like, all the people detained in the transit zone were represented by our attorneys. So we would make a compilation, a statistic, how long those people were detained in average in the transit zone. So we published this kind of document, and it was referred to in the Commission's pleading at CJEU, at the case. So we believe, and several other documents that we were publishing, I think they were used in the submissions. So this, we think, it's a very good way of influencing the infringement procedure, that you try to have as many documents available on the website as possible that would assist the case. And then the judgment came in December 2020, of course, finding Hungary in breach of the EU law. Unfortunately, Hungary is not willing to comply with this judgment, so the Commission referred the case back to CJEU, requested sanctions in February 2022, and then in June last year, the CJEU issued another judgment, and there they really condemned Hungary and imposed a very high financial sanction. Its lump sum is 200 million euros and 1 million euros a day for non-compliance. The court said that this is really a serious threat to the unity of the EU law, and the breach of EU law is so severe and unprecedented that high financial sanctions should be imposed. What was also crucial here is, I already mentioned this case, the FMS case, right? So this was a preliminary reference on the question of whether transit zone detention is actually detention and if it's illegal, and on some other, it's quite a complex case. There were many other questions raised. So this preliminary reference case was decided, you can see, before the pushback case in the infringement procedure was decided. But this case also covered the transit zone detention. So this kind of made the job of the CJEU very easy, because they just referred to all the findings they had in the FMS regarding the transit zone detention. So it's important to know that, if you can, you should run. Even the Commission already started an infringement procedure, it would still be useful if you have a chance to have a preliminary reference ask and have these procedures run parallelly. We also did the ECHR cases parallelly, and that's also important because exactly in the FMS case, for example, it turned out, that the FMS case kind of saved the whole situation, because the Ilyas and Ahmed judgment from the ECHR prior to that said this is not detention. So it's always good to try to litigate at different levels, when it's a new issue, when you don't know which court will actually be more understanding in the human rights applications. But for the pushbacks, we did run the ECHR litigation in parallel, and there we have positive judgment from the ECHR2 confirming that this legislation is in breach. It's collective expulsion, so in prohibition of, in violation of Article 4 of Protocol 4 of the Convention. Then the second case is the access to asylum case. So as you know, since June 2020 in Hungary, you can no longer apply for asylum, neither at the border or in the territory. You have to apply at the embassy of Kiev or Belgrade. And only then, if this intent is taken, then is accepted, and then you are invited to enter Hungary and then go through the full asylum procedure. This is a clear access issue, a violation of procedures directive. And here you can see the infringement procedure was initiated a few months after the legislation entered into force. And then half a year after was the reasoned opinion, and then the case referred to the same year to the court, and we had the judgment in June 2024. Now, it's been more than a year that the Commission did issue a letter of formal notice to the government, because nothing has changed. The law is still in place. You cannot apply for asylum within Hungary. And it's been more than a year now that this letter of formal notice for not complying with the CJEU ruling is being issued. So we are expecting from the Commission to now refer the case back to the court to get and to demand financial sanctions also in this case. This case did start, well, again, as I said, we don't know if Commission started infringement procedure by because Helsinki Committee submitted a complaint, but we did submit a complaint. There is a complaint form. It's not that difficult to fill, so I would encourage everybody, if you have an EU systemic problem of EU compliance, EU law compliance, do submit a complaint. Again, we were providing answers, answering inquiries from the Commission. Our advocacy officer had meetings with DJ Home, but at the same time, we were also not forgetting the Strasbourg part, and there is this procedure to the supervision of the implementation of the judgments at the Committee of Ministers, and this embassy deprivation of access is addressed in the cases there, Ilyasek, Ahmed, and Shazad. So we were submitting Rule 9. Many Rule 9s in that procedure, hoping that, pressure from different sides might help. And now I go to my last part, which is the attack on civil society. It's not directly migration related, but migration is part of the reasons that we are under the attack. And I want to speak about that. There was an infringement procedure started in July 2017, where a first legislation that attacked NGOs, its so-called Lex NGO, was adopted. So there was this, I don't know if you remember, but there was this obligation that an NGO should register and declare publicly and on every publication that, we are foreign funded, so that we receive foreign funding. So there was supposed to be these stickers on each and every publication, and you had to enter into this registry if you received any funding from abroad. And if you did not do that, then you would be fined. Like, there were financial penalties for not complying. So Commission acted really fast. Now, this I really want to emphasize, that so far our experience when it comes to this kind of rule of law attacks on civil society or other segments of society, then this Commission is really fast. You can see the law was adopted in June. In July, infringement procedure started, reasoned opinion already out in October, referral in December, and then, okay, it took a long time for the courts to decide. That's another story, but still the Commission, the infringement part, that was really fast. Why I put a question mark? Because after the legislation was repealed, so there is no more Lex NGO, but we will hear what's happening now at the end. Then another infringement case in this same category is the so-called Stop Soros case. That was when in July 2018 legislation was adopted. Partially was about the introducing new inadmissibility grounds, so something why you can reject an asylum application, but based on criteria that do not exist in Asylum Procedures Directive, so clearly not compliant with Asylum Procedures Directive. But then the criminalizing part of legislation was that the criminal law was amended, and there was up to a year imprisonment for providing assistance in making or lodging an asylum application. for a person whose application could not be accepted under the law. So very vague, what was that? When an application for asylum cannot be accepted. And then also there was this ban if a criminal procedure would start, that you can't access these 8 kilometers next to the Serbian border area. And that's where the transit zones were. So the first fear was, all our attorneys will be, put under criminal procedure so they can stop providing legal assistance at the border. Luckily, this legislation was never really implemented in practice, but it created a huge chilling effect. We had to limit ourselves. Many other organizations had to exercise censorship. But now, if you look at the timeline, again, you see 1st July was adopted. On 19 July, infringement procedure already started 18 days after. I think also because before this Stop Soros package was adopted, we were already analyzing it. There was already public writing about it, so Commission was already fully aware what is coming up. So they were able to react really fast. Then the recent opinion followed in half a year. An action was submitted the same year, and then there was a judgment from November 2021. So again, you see the main point here is that you should publish, even though the legislation is maybe not even yet adopted. It's important that you write about it in English on the website. It's accessible. You share with relevant contacts around. Also meetings, if possible, that you conduct meetings with the Commission. And in this concrete case, we also had a preliminary reference running in parallel, which was about this new inadmissibility ground, safe transit countries. So when the judgment came out, already, they could just refer to the LH judgment from March 2020 that addressed that issue. So that was also helpful for the court. And now, and the last already still pending case, so in this section, is the so-called Sovereignty Protection Act. In December 2023, Hungary adopted the Sovereignty Protection Act, which established a Sovereignty Protection Office. This office is empowered to conduct large investigation of organizations that they believe that are financed from abroad and that they believe that they are influencing the outcome of elections and that they conduct actions influencing the electoral will. Now, who was the first organization that started to be investigated under the Sovereignty Protection Office? So not some kind of organization that is connected to a political party, or, you would think that it's really like connected to the elections. No, it's Transparency International. So Transparency International was the first organization that investigation started against, and an ATLAT, so another organization that is independent investigative organization, that they disclose cases of corruption. So now they are investigated with the Sovereignty Protection Office being suspected of, acting against national sovereignty. The Sovereignty Protection Office can get information from the intelligence agencies, and you can't have any legal remedies against this procedure that Sovereignty Protection Office is conducting. And people working at this organization can face prison sentences if at the end is found that, they did use funding for actions influencing the elections. And here, again, very fast reactions from the Commission. 2 months after the law infringement started, recent opinion in May, then in October, CJEU referral. And then what is new, what didn't happen in other cases, is that Commission, while the case was pending at CJEU, they requested for expedited procedure. That last December, and the CJEU granted expedited procedure in February this year. So this is going to be then hopefully faster than we saw in this first case, where it took like 3 years to decide for the CJEU. And my last contribution on the attacks of civil society, I cannot not say it because it's really terrible what is happening. So last week there was a new law submitted to the Parliament, so-called transparency law, which gives the powers to the Sovereignty Protection Office to blacklist organizations, media outlets, individuals, not just NGOs, also private companies, that interfere in public life with the support of foreign funding. Interfere in public life, you can see. So basically, if you speak up against the government, you can be blacklisted by the Sovereignty Protection Office. The consequences are extreme. The banks are supposed to freeze the foreign funding you are to receive. Foreign funding meaning EU money, UN money, or any other foreign funding. So you win a project, a new project, bank freezes this project's money because it's coming from the EU, and then the National Tax Authority need to approve whether you can get it or not. We can assume whether approval will come or not. At the same time, you can't get the 1% personal income tax donation. And all, which is really scary, is that all current contracts that we have with, for like with EU, with UN, with any other foreign foundation that supports medias, civil society, these contracts are big. If you are listed on this blacklist, then they are all null and void. Activities have to stop, and you have to return all the non-spent money. So the operation of this year is already in question. If you don't obey with the provisions in the law, there are huge fines, like 25 times of the funding you're supposed to receive. And if you don't comply with that, the organization can be dissoluted. So we can't operate anymore, and there are no regular judicial remedies, only appeal to the Supreme Court, where the head of Supreme Court is politically appointed person, and the managers of the organizations become public figures, which means they have to disclose all their assets, and they are under scrutiny for the terrorist and money laundering activities. So this law will be voted on in 2 weeks, 10 to 12 June. Of course, the government has 2/3 of the ruling party has 2/3 majority, so we expect it will be adopted. In what form this we can't tell. I would like to say the words of our director here, that if this law passes, then this will not simply marginalize Hungary's independent voices, but it will completely extinguish them. So it's a really serious threat that does not affect just Hungary, but this illiberal democracy spreads around across the borders. So it's a very serious problem, and therefore we are calling for the European Commission to actually issue an interim measure, in this case already pending. It's not about the same act, but you can see it's the same Sovereignty Protection Office that got even further competences to act in this field. So we believe the most appropriate action would be an interim measure request by the Commission to actually not have this law being in force in Hungary as of 2 weeks from now, and also that this Lex NGO is again referred, even though the Lex NGO was repealed, but this same case could still be referred back to CJEU, because we believe that, the NGOs are again under even more serious attack because of the funding they receive from outside Hungary. If you are interested in this, what we are fighting now, the transparency law, there is a brief on our website, and once the PPT will be shared, you can also check. So this is my last slide. Just to repeat what I think, civil society actors can do. publish, inform, publish, talk about. So I know you are already overburdened with everything, but it's really important to speak about things. It will help the Commission if they have, already an analysis of the law available even before the law is adopted, or whenever there is an issue, like just publish one page about it, an info note, because not like there are lengthy yearly reports about the asylum system. Yes, fine. But what really helps is short, straight to the point info notes on concrete issues and what's the EU angle problem with it. Do file complaints. Of course, sometimes they won't be followed up, but still doesn't mean you shouldn't. And follow up, because commissions sometimes, from our experience, sometimes these complaints get lost or are not properly registered. So don't be afraid just to write an email asking what's happening with my complaint. Also get in touch with the European Commission. Of course, there are new rules on the transparency, which means that all the meetings you have, discussions with the high management of the EC in the departments, then this will be recorded and the minutes will be publicly available. So bear this in mind. And my final advice, yes, so as I already said during my presentation, continue to litigate. Don't put all your hopes on the Commission, but try to achieve preliminary reference, or go to Strasbourg if you think it's good for the case. And if you have any questions, you can always write me or ask now. Thank you.
Thanks a lot, Gruša. Thank you. We have some echo, I think, there. Thank you for this introduction to infringement proceedings, and also for the concrete examples you shared. Also, thanks a lot for raising this situation currently in Hungary regarding the bill proposed last week targeting civil society and independent media. It is really very serious. So just to say, also we as ICJ were also just about to finalize a statement supporting the call that you mentioned for the Commission to actually start immediate measures within the existing infringement proceedings, or potentially to start new ones immediately would the law pass. But thanks a lot. And there is one comment or question, I think, in the chat already from Rashid. I think we'll have like 5 minutes for questions, discussion. So feel free again to raise your hand or write to the chat. And Rashid, if you'd like to come in. Otherwise, I'll just quickly. Yes, I'll just read the question quickly for you, Gruša. So recently we have observed that an increasing number of countries are defying or disregarding the mandates of international organizations, international tribunals, and established international law. These actions cast serious doubt on the effectiveness and legitimacy of our global legal framework. In light of these developments, what future do you envision, and what is the way forward?
Well, I'm not sure I'm the right person to answer this. I'm not a visionary, or I'm a lawyer, and I still believe in the legal system. I still believe in the European Union law, and even despite some very negative judgments from Strasbourg, even that court, I still have hope. So we continue, like putting our hopes to the mechanism of the European Commission, infringement procedures, CJEU, and other international courts. So here I can't really comment. Sorry, I hope it won't die.
Thank you, Gruša. And I'd just add, from our perspective, we see a lot the same. We, of course, also struggle seeing, the lack of implementation generally increasing of international judgments. And it's becoming increasingly more difficult to use the international legal framework to defend human rights. But I agree, we keep fighting. And I think there are cases, and, it's kind of a way back and forth. And you fail a few times, but then you succeed. So I also think we need to believe in the law and in international law, especially in the international mechanisms. although they are not so strong, there are still some mechanisms that we still have. So I see Tomáš's hand up, if you would like to come in.
All right. Thank you very much. I've put the recommendation of a Schengen evaluation. It's a European Commission and Member States evaluation of Polish return system. And it includes prioritized recommendation to implement Directive 2008-115, Return Directive 17 years old. And it's not been implemented so far in providing legal assistance to returnees. If we have such a report right now with various proofs of violation of EU law, lack of implementation, shouldn't it be like automatic start of the European Commission's actions to send a inquiry letter to Poland how Poland is thinking of implementing and providing pro bono legal aid or state-funded legal aid in return procedures? Because this is something that we have. It's quite fresh report, but a long problem. So we are thinking of starting this case, and I believe infringement case would be great, because we can't get access to legal aid for our clients, returnees who are not providing access to legal remedies, unfortunately. What do you think? What would you recommend?
I definitely think you should start with the complaint. Now, as I said at the beginning, this is, Commission is choosing which battle to fight. Now, with Poland, you had all these crisis at the border issue. I don't know how much they are willing, or you had the rule of law issue with the previous government. So I don't know how much the Commission is now willing to, go against Poland in every single case, but we don't know that. Nobody knows. I mean, it's political decision. So I say don't, do start with the complaint, do raise this issue. You have a report, then the form is really simple to fill in, and then follow up. They have to register it, they have to answer in a reasonable time. So I hope they will pick it up.
Thank you.
And just maybe for the previous question, I just remember, so yes, non-implementation, and yes, the pushback case, they don't pay this financial sanction, but this doesn't mean that, nothing happened, right? Like Hungary simply doesn't get the money that should be getting from other European projects, right? So I don't know, constructing this building with the EU money, then they would issue an invoice and they would not be compensated for. So the whole country is losing the money, not by paying directly the fine, by not being reimbursed for the cost. So in a way, this does have, an effect. So I don't know how long are they willing to blatantly, ignore this judgment and not getting money from the EU because of it. But there is at least some kind of mechanism that is running, and hopefully there will be some change at one point.
Thank you. Thanks a lot, Gruša. And I think with that, we'll have to finish. We're already running a little bit behind the time, but thank you all very much for joining. Thanks a lot, Gruša, again for sharing all the information with us and for the advice. So thanks to all for your active participation. We're planning 2 more webinars this year focusing on litigation venues different from the CJEU, on the UN CRC, on the European Committee on Social Rights, and also on the European Court for Human Rights. So we will keep you posted. And also my colleague has just shared this feedback form in the chat. So we'd be very happy if you could fill it in for us as well. So thank you so much, everyone. We keep in touch. Have a nice day.